All right, so let's take a look at the federal trial that Chille had. First of all, going through trial is a very exhausting, difficult process. And I give him credit, give Chille credit, calling balls and strikes here. A lot of people say, yeah, let's go to trial. And then, when you get to the second year mark, they're already kind of fading fast. A lot of people, they don't want a trial anymore. They want to settle or maybe just drop the matter. Chille didn't. To his credit, he still got several claims all the way through where they went before a jury. So I got to tip my hat. So first, we're going to look at some stuff I had predicted a while back, just to kind of bring our memories fresh, and then we'll get started.
Again, I'm saying this without any background on what exactly happened. He said he filmed the cops, but it sounds like the cops gave him lawful orders and he refused.
I didn't have
probably on body camera.
And it was.
Body cam, which is going to be used against him as well.
It was.
Did he fail to give them the proper ID? Did he refuse to ID, Did he slow them down and make them repeat the same question 40 times?
That's the Willson exception.
These are hard charges to beat. And my prediction is, just based on his pattern and practice, he's going to get convicted of at least one charge, probably two. And he's going to then get probation, where he's going to have to now comply with a lot of things, or he's going to be back now looking at real jail time. And here's where things can get really bad for him. They could run those misdemeanor sentences consecutively.
All right, I'm looking at these as fast as I can. The first day of trial, I'm actually looking at them as you are. Trial goes off the record, prospective jury panel, 44 jurors, Sergeant Torrey's testimony. So here's the first witness, Erland Torrey. His testimony continues. His testimony concludes. Brandon Borg testifies. So now we got our second witness. He's the star of the show, guys. Then Sandoval. He continues and is excused. Okay, so Sandoval definitely testified. And then Doolittle testifies. Dingle comes up next. He didn't last very long. Basically an hour. Sorensen is next. Didn't last very long either. Was that an hour? Now Chille testifies. Okay. Kind of unusual. Chille didn't go first. Okay, Mr. Anderson, the new trial attorney, moves for a mistrial. Arguments heard. Now, a mistrial would result when you violate a court order that is significant. Violating a court order is significant. Anyway, Business Professional Code 6103 holds lawyers liable for suspension or disbarment for violating knowingly, willfully violating a court order. So I don't know exactly what Chille said. So a mistrial means starting the trial all over again. Normally what would happen is the judge will issue what's called a curative instruction to the jury and say, you can disregard that. It means nothing. It was said, but it doesn't carry any weight and you're not to think about it anymore. Then they will think about it. Okay. So Chille is continuing to testify. Okay. 3 exhibits are admitted into evidence. These are defense exhibit numbers. Remember, it's what gets admitted that matters. Okay. So let's go to day 4 of the trial. Okay, these are the pre-trial meetings with the judge, jury instructions. Got to get them done. They're always a pain in the ass. Chille's continuing to testify. 524 is admitted into evidence. What's with this thing? Okay, now Chille's testimony stops. All right, so he wasn't up for very long, really. Jury enters the courtroom. Closing arguments started, right? Plaintiff rests. All right, now when plaintiff rests, this is when you can bring motions to try to win the case. But no, they brought him back. Officer Bork is called to the stand, swore, testifies, excused. So the defense is continuing with its case. 505 and 513 are marked and admitted into evidence. So they started deliberations on February 12th, which was the day before. And at 11:39, they came back with the verdict. This to me indicates that these were exhibits that were entered into evidence. Okay, so when Bork was testifying, witness exhibits 405 and 504 and 505. 518A, YouTube video, lawsuit filed, delete laws, is arrested for filming cops by, is Bork? Is it because of the word pork? And then 519, I didn't see it, but it seems to be listed as an admitted, it's date, mark date omitted. Shouldn't that be admitted? That sounds like a typo. Then 520, DLZ follows a rigid set of policies, procedures, and protocols. There it is, 521A. We don't stop. And then 524, DeCastro's second amended complaint. You know, there's not a lot of exhibits here. 1, 2, 3, 4, 5, 6, 7, 8 exhibits. All right. Now the jury verdict form, we already looked at this. Here's how it's basically set up. Brandon Bork had probable cause to arrest Chille, and the judge gave an instruction, and they said, yes, he had probable cause. We get to the next one, a lawful search and seizure, invasion of privacy claims against Bork. Well, if you've already said that he had probable cause, what do you think is going to be the outcome for the next set of questions? This one, did Brandon Bork batter or use excessive force against Jose DeCastro? No. Did Jesse Sandoval batter? No. Did Brandon fail to intervene in Jesse Sandoval's use? Well, you only answer this if you answered yes to 7. Yeah, and so nothing to answer there. It's all skipped. First Amendment retaliation. Now, if you answered yes to question 1, arrest plaintiff when other similarly situated individuals not engaged in the same sort of protected speech are typically not arrested. I have a problem with this question. The double negatives. I'm wondering if the word not was supposed to be taken out of this. Did defendant Bork arrest plaintiff when other, take the word not out, the first one, when other similarly situated individuals engaged in the same sort of protected speech are typically not arrested? See, that to me is really the question, that this question is wrong. And then you get a double negative that you answer with no. See how this can get a little bit problem? You know, Chille, you know, this is something you got to be thinking about right now. Am I off base here? So the first question was there probable cause to arrest Chille? And the answer was yes. So now they come down to 18. Did Bork arrest plaintiff when other similarly situated individuals not engaged in the same sort of protected speech are typically not arrested? I have problems with the way this is worded. It's not easy to understand. When other the way the question would come to me is, did you arrest him when other people who are doing similar things are not arrested? In other words, that's the retaliation. The retaliation is you arrested him when others would not be arrested for doing what he's doing. But you're saying not. You threw, I think, an extra not in there, and I think the jury instructions have a mistake. I do. Did Brandon Bork selectively enforce the law against Jose based on his filming or speech? See, now this is a much more targeted question. One of the problems with giving somebody $1 is it could be a recovery, and therefore, does that trigger attorney's fees under the civil rights claims because there was a monetary recovery? I don't know. I don't handle civil rights cases like this, but that's something to be very careful of. So here's the things. This means that you must decide the case based on what is in front of you, nothing else. Don't bring in outside sources. That's fine. I'm going to skip over. You decide a witness has lied, you can disregard that or everything they say. It's up to you. That's your job as a juror. DeCastro claims he should not have been arrested because his conduct was protected by the First Amendment. DeCastro contends that the defendants arrested him without probable cause, used excessive force, retaliate against him based on his exercise, blah, blah, blah. These are very high level, you know, And then preponderance of the evidence, he'll explain to you what that is here. The claim is more probably true than not, which is greater than 50%. False arrest. DeCastro claims Bork falsely arrested him under Nevada state law. Preponderance of the evidence, because it's a civil case, arrested him without probable cause. Then is the definition of probable cause. Now look at this. This is the reason I had trouble with these statutes in the first instance. To willfully hinder, delay, or obstruct any public officer to discharge official powers or duties. Notice that it has the word delay, obstruct, public officer, and discharge in duties. For a person to willfully resist, delays, or obstruct a public officer in discharging or attempting to discharge any legal duty of his or her office, delays, obstructs public officer discharging their duty. See how these statutes overlap each other? I mean, so to willfully obstruct is obstruction. A person willfully obstructs is resisting arrest. There's no way that makes any sense. A person who willfully delays can be guilty of resisting arrest. And a person who willfully delays could be guilty of obstruction. Do you see why I said that these statutes are unconstitutional, at least as to one, because it's borrowing language from the other? The Hiibell decision. Interestingly, the Hiibell decision is in his trifold. And when the Willson court said that the statute was now had to be reinterpreted under, with an specific intent, and it would only apply to fighting words and physical conduct, there was an exception to it, which I've been calling the Willson exception. Passive aggressive conduct, an intent not to cooperate would still qualify as physical conduct and still be a basis for conviction. So to the extent that Chille did not cooperate with the officer, even if he did not try to hit him and he's not using fighting words, he'd still be convicted under the statute. I'll get to that in a second. But this decision, he talks about Terry v. Ohio all the time. The Willson court, while reviewing the unconstitutionality and how they're going to fix this terrible obstruction charge, never even found this case. I found it. Chille never used it at his trial. It was missing persons. What are words for when no one listens anymore? It says it's like appearing at the end of a page when you realize you just don't know what you just read. All right. Why does this case matter? Well, I'll tell you why. Here's the Terry v. Ohio we're so fond of. It gives you a framework to analyze the two statutes to get them overturned, because if you'll remember, I was rooting for Chille to overturn these two statutes. And why was that? Because the poor get snared up in bogus bullshit statutes. The obstruction statute was last revised in 1911, okay? And it was so bad that even the appellate court really couldn't understand the rationale for it. False arrest. DeCastro claims Bork falsely arrested him under Nevada state law. Preponderance of the evidence, because it's a civil case, arrested him without probable cause. Then is the definition of probable cause. Now look at this. This is the reason I had trouble with these statutes in the first instance. To willfully hinder, delay, or obstruct any public officer to discharge official powers or duties. Notice that it has the word delay, obstruct, public officer, discharge in duties. For a person to willfully resist, delays, or obstruct a public officer in discharging or attempting to discharge any legal duty of his or her office, delays, obstructs public officer discharging their duty. See how these statutes overlap each other? I mean, so to willfully obstruct is obstruction. A person willfully obstructs is resisting arrest. There's no way that makes any sense. A person who willfully delays can be guilty of resisting arrest. And a person who willfully delays could be guilty of obstruction. Do you see why I said that these statutes are unconstitutional, at least as to one, because it's borrowing language from the other?
The DA is not saying anything, and the judge is relying heavily on these two attorneys to sort it out in her mind. So you've seen this, it's all narrated, and ask yourself if any of these statements by Chille would violate a lawful order to comply. If so, under Nevada law, he's guilty of obstruction.
Pulled over. Oh, I see. Hey, back up. Back up. Not involved. Oh, I see. Oh, gotcha. You can film, but you need to stay away from my driver. Back up.
Okay, so we have back up. Oh, I see. You know, I give Chille the benefit of the doubt there, but stay away from my driver, back up. So now there's a second command to back up. And right here, the cop is saying, okay for filming. So Chille, you're going to have to resolve that.
Back up or I'm going to detain you.
Now, you guys haven't been talking about this. I've been bringing it up from the very beginning. Chille questioned whether or not he was going to be detained and then consented to being detained. Third request to back up. So Chille has backed up.
You're going to detain me how? In which way?
Away from my car.
Actually, I'm standing right here.
I'm standing right here. He's not backing up any further, guys. That's obstruction. I'm standing right here. Standing right here sounds like he's not going to move. I didn't hear any of that being brought up by Orem.
I'm at least 10 feet away, officer. I got to tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the law, sir. Mind your own fucking business.
Not your business.
Mind your own effing business. And once again, the cop is saying it's all about privacy. So this is where Chille goes hard. The 21-foot rule, complete bullshit, has nothing to do with the case, had nothing to do with officer safety. What's his face? Bork admitted it because he said, I wasn't going to write a resisting arrest charge and pile on because I didn't think the guy was a danger to me. Did you hear that discussed at oral argument? This isn't offensive language. This is open defiance. And Orem never brought it up, and the DA never brought it up. It was never mentioned in the appellate briefs.
Not your business.
Mind your own business.
Mind your own business? That's Chille. That's obstruction.
I'm a member of the press. Go get in your car and do your job, little doggy.
Now, notice how this statement was brought up as deemed cooperation by Orem, which it wasn't. But Orem skipped over the mind your own effing business, mind your own business, on top of I'm standing right here. Go get in your car and do your job. Orem took this statement out of context.
Go feed her.
You're being detained right now.
Okay, then detain me.
You're being detained right now. Okay, detain me. So there is no unlawful detention. Chille's just consented to it.
You're not.
Was any of that brought up at oral argument?
15, Rodriguez.
Over my car.
Don't put your hands on me.
Over my
Don't touch
car
me.
now.
Don't put your fucking hands on me.
I am going to put my hands
No,
on
you're not.
Was any of that brought up at oral argument? All right, so let's go to the signed order by Judge Leavitt, and it will include everything but what could have convicted Chille, which is just amazing. It does not accurately state the Willson exception. Notice that it says the Willson decision establishes fighting words, physical conduct, obstructing the pathway, or fleeing an officer are standards that apply to obstruction. These are not the only standards. This is an incorrect statement. Honestly, now says that these are the only categories that the court had to look at, was whether or not he fled, which he didn't, or if he obstructed a pathway, which he didn't. So, you know, there it is. This is a false representation of what actually the case says, and the order is false. The order is wrong.
Because they don't even, because there is no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control.
So he did nothing physical. The officer just lost control. The Willson exception deems physical conduct to include the disobeyance of a lawful order. So Orem is totally wrong here.